For years, the smell of cannabis alone was enough to justify a police search. In Virginia, that rule has changed. Today, we are breaking down exactly how cannabis odor affects probable cause under Virginia law, what officers can and cannot do, and why this legal shift matters to residents, drivers, and communities across the Commonwealth. Here's the context. Cannabis laws in Virginia have evolved rapidly over the last several years. While many people focus on legalization headlines, fewer understand how these changes affect everyday police encounters. One of the most misunderstood areas is cannabis odor and whether it still gives law enforcement the authority to search a person, vehicle, or property. This video is not about lifestyle, advocacy, or promotion. It is a legal and policy-focused explanation of how Virginia courts and statutes currently treat cannabis odor in probable cause analysis. Here's the legal background. Historically, courts across the United States recognized the odor of marijuana as sufficient probable cause for a search. The reasoning was simple. If marijuana was illegal, the smell indicated criminal activity. Virginia followed this approach for decades. However, once Virginia decriminalized and later legalized limited possession, lawmakers were forced to reconsider how odor alone fits into constitutional standards under the Fourth Amendment and the Virginia Constitution. Current Virginia law explained. Under Virginia Code Section April 1, 1302, law enforcement officers may not initiate a stop, search, or seizure based solely on the odor of cannabis. This includes both burnt and unburnt odor. This is a critical distinction. The law does not say odor is irrelevant. It says odor alone cannot establish probable cause. That means officers must identify additional, articulable facts beyond smell to justify further action. What counts as additional factors? Examples of additional factors may include observed impairment while driving, visible contraband, admissions, or other lawful indicators. Odor may be part of a larger analysis, but it cannot be the starting and ending point. This legal standard is intended to prevent pretextual stops and searches while still allowing law enforcement to act when legitimate safety concerns exist. Who this affects? This law impacts drivers, passengers, property owners, and even pedestrians. It also affects how officers document encounters, how prosecutors evaluate cases, and how courts review motions to suppress evidence. In regions like Norfolk and Hampton Roads, where traffic stops and urban policing intersect frequently, understanding this standard is especially important. Check out this scenario. Imagine a routine traffic stop in Norfolk for a broken taillight. The officer smells cannabis coming from the vehicle. Under current Virginia law, that odor alone does not authorize a search. If no other factors exist, the stop must remain limited in scope. Now imagine the same scenario, but the officer also observes erratic driving behavior or visible impairment. In that case, odor may contribute to a broader probable cause analysis. The distinction matters. Why this matters? This change reshapes police practices, court challenges, and individual rights. It also affects case outcomes. Evidence obtained in violation of this standard may be subject to suppression. For communities, this law represents a shift toward limiting discretionary searches and reinforcing constitutional protections. For officers, it requires updated training and careful documentation. What to watch next? As Virginia law continues to evolve, courts will further define how odor interacts with other factors. Local enforcement patterns, appellate decisions, and legislative amendments will continue to shape this area. If you want deeper analysis, case citations, and local enforcement context, we publish full legal breakdowns on the Norfolk City Cannabis Community platform. Here's a question. Do you believe the change in how cannabis odor is treated under Virginia law has improved fairness in police encounters, or has it created enforcement challenges? Put your answer in the comments. Please like, comment, and subscribe for more educational Virginia cannabis law analysis. If you found this explanation helpful, please take a moment to like the video. Your engagement helps this educational content reach more Virginians who are trying to understand how cannabis law is actually applied. Feel free to leave a comment with your thoughts or questions, especially if there are specific Virginia statutes or enforcement issues you would like covered in future videos. And if you want more clear, Virginia-specific cannabis law analysis focused on policy, regulation, and constitutional standards, consider subscribing to the channel so you do not miss future updates.